Probably wasn't all that interesting. I'm just all riled up this morning because of TikTok Live. All right. If you were not here Tuesday, be sure that you watch the video because we talk about kind of the remaining schedule for the semester, what all's left out there, some important dates for you, and the remaining schedule has been posted to this week's content module. So I would encourage you to take a look at that. And I would encourage you that if you have any questions about where you stand or any work or anything like that, now is the time to ask and get with me, not once your final exam is done and grades are in. So we started talking on Tuesday about contract law, and I'm going to try to finish lecturing on contract law today. If I don't quite finish, then next Tuesday we'll wrap it up. And then next Tuesday, we're also going to discuss the cases that have been assigned to you. So you'll see in this week's content module that there are 2 cases. So for next Tuesday, you need to make sure that you read those. There is not a quiz due Monday night, but there is a quiz due the following Monday night. So we're going to spend 3 class periods on contract law. And then we will not have class next Thursday. Got to go to Atlanta to speak at an adoption law seminar next Thursday, and so I will not be here. So 3 classes worth of contract law, 1 quiz that will be due in 2 weeks, and then we'll move on from there. Anybody have any questions? Yes, sir.
When is the discussion going to be posted?
I need to do that today. That's a good question. I just have not gotten around to that yet. Okay, if nobody has any questions, then let's jump back into contract law. So Tuesday I gave you some sort of broad overview of contract law, some of the main things I want you to keep in mind as we go through, some of the main lessons for contract law. And we talked about the 4 main elements of what makes a valid enforceable contract. That being agreement, and we got into offer and acceptance pretty deep. The second element is consideration, which is where I'm about to go next. The third element is capacity, and the fourth element is legality. So today I'm going to cover consideration, capacity, and legality. If I can, and I think I've got enough time to do all that. All right, so consideration. This is the element of a valid contract that has to do with the value that is exchanged between the parties. Consideration is what differentiates a contract from a gift. Both parties have to be giving up something of value. All right, notice I did not say that both parties have to be giving up something of equal value, just that they have to give up something of value. The law does not get involved in whether or not you made an equal deal, you made a good, fair deal. The law allows you the freedom to make whatever deal you want to. And as long as the other side wasn't misrepresenting facts or perpetrating some sort of fraud on you, you are left with the responsibility to make your own decisions and enter into whatever contracts you want, to give up whatever value you think you want to give up for the promise that you're getting in return. That's the idea of consideration. Okay? You have to promise to do something that you're not already bound to do. All right, so if somebody is already legally bound to do something, then that cannot be used as consideration. Here's an example. I signed a contract last summer to teach at CSU for this academic year. All right, that contract says they will pay me X dollars and I will teach 4 classes per semester. Now that we are almost halfway through that year, I can't go back and say, hey, Dean Kidder, I'm not going to teach unless you give me a $10,000 raise. If she's like, well, I got to have somebody to teach, you can have a $10,000 raise. I haven't given any consideration for the raise because I'm already legally bound by contract to teach this year. Okay? I'm already legally bound to do it. Consideration cannot be something that has happened in the past. I gave y'all the example Tuesday of you guys somebody giving me a ride after class for $10,000. Okay, if I asked James last Tuesday, will you give me a ride to work after class? And I don't promise to pay him anything. And he says, sure, he gives me a ride. And then later on, I say, I'll give you $10,000 for that ride. I really appreciate it. That's too late. He's already provided his service or his promise to me without my promise of giving him the money. So it can't be past activity. It can't be something that you're already legally bound to do. Keep in mind that consideration can be doing nothing in the form of if a person restrains from doing something they have a legal right to do. That could be consideration. There was a famous case where a great uncle or a great aunt promised some nephews and nieces if they did not drink or have sex before they turned 21, she would give them a certain amount of money. And they didn't. And I can't remember how they got in crossways about this, but somehow it got in the court system. And the defense of the great aunt or uncle was that you didn't give up, the nephews and nieces didn't provide any consideration. This was really just a gift. The court said no, they gave up something that they had a legal right to do. This was back when the drinking age was 18. They could have, but they abstained, they refrained from that, and so they did provide consideration. Agreements that lack consideration, that's kind of where I am. The pre-existing duty, we just talked about that. Past consideration, we talked about that. Another way that consideration might be lacking is if there are what we would call an illusory promise, meaning that the promise made by one side is just too indefinite for us to be able to measure whether or not it's consideration. An example of that would be I manage Petland and I tell Tim, if you work hard between now and the end of the year and we end up having a good year, then I'll give you a big bonus. Okay. The consideration from me is that I'm going to give him bonus. Consideration from him is that he's going to work hard. The problem with it is that how do we know what a good year is? Does that mean that we made money? Does that mean that we made a certain amount of money? Does that mean is a good year that we didn't burn the store down and get shut down? Is it a good year that none of our animals died? I mean, I don't know what that is. So an illusory promise might lack consideration. Now, the courts are not generally looking for reasons to do away with a contract or find that the parties didn't have a contract. If the parties intended to enter into some kind of agreement, the court's going to want to uphold that. It's just got to be able to have enough definite terms to do so. So an illusory promise would lack consideration. So zoom back out for a minute. In most of the topics we've covered so far, we've talked about defenses. Like what would a defendant use to escape liability or avoid liability? Defenses in contract law would be that one of the main elements is not does not exist or is not met. Like if I've taken you through all the things that are required for an agreement, a defense would be, well, you didn't make a definite offer. Your acceptance didn't mirror the offer. The offer wasn't communicated to me. Remember all the things we talked about Tuesday. Defenses to the consideration element might be, well, the promise was illusory, or you had a pre-existing duty, or the consideration was already given in the past. The flip side of everything that's required would be a defense to whether or not there was a valid enforceable contract. All right, there are So now that I've talked about the fact that a court will not enforce a contract if there's not consideration given from both sides, I'm going to hopefully not confuse you by talking about two situations where a court might still enforce the contract even if there is no consideration. All right, there are times when the defense might be, Judge, I can't be liable. There is no contract. There was no consideration provided. In very limited situations, the court might say, yes, you're right. There is no consideration, so we don't have a valid contract. But I'm going to enforce the agreement anyway. Or I'm going to enforce the agreement at least to the extent that the one party has been injured. Here's what that looks like. There are two ways. One is called promissory estoppel. Estoppel is a weird word. Promissory estoppel means that someone made a promise. There may not have been consideration coming back the other way. The person that the promise was made to relied on it to their detriment. And the only way that justice can be served is if we enforce that promise. Here's an example that'll make this easier to understand. Boys and Girls Club is raising money to build a new clubhouse. I tell Boys and Girls Club that I will give them $2 million for their clubhouse. All right. We don't have a contract. Why? Why would that not be a contractual agreement?
Because there's no consideration.
Well, the Boys and Girls Club's not doing anything. They're not doing anything for me, right? So it's not a contract. It's a gift from me. Say, well, wait a minute, Professor. You said that if consideration is lacking and there's a gift, the courts won't enforce it. Most of the time, no. But let's say that I called up the Boys and Girls Club and I promised them $2 million. And in reliance on my promise, they go out and buy land for their new clubhouse. They hire an architect, get plans drawn up. They hire a contractor to do the work. Everybody gets ready, gets started, and then I call up and say, just kidding about that $2 million. Psych. All right. They sue me. My defense is, it's no contract, Judge. They didn't give me anything in return. And the judge might say, yeah, that's true, but I do have this little thing called promissory estoppel that I can use. And I could use it to force you to go through with your promise, even though there was no consideration, because you made the promise, they relied on it to their detriment. And now the only way for us to avoid injustice is to make you go through with what you said. Now, let's take that same example, but assume that I call them up, I make the promise of $2 million. The next week, before they have bought any property, before they have hired an architect, before they've hired a builder, before they've undergone any expense, I call them up and tell them I changed my mind. All right. They sue me. I tell the court, well, there was a gift. It's not no contract because they didn't provide any consideration. The plaintiff might say, okay, Judge, but you could use promissory estoppel. My defense then is, no, Judge, they can't use promissory estoppel because even though I did make the promise, they haven't relied on it to their detriment. That was just a week ago. They didn't buy any new land. They're not out any expense. They're not out any other opportunity costs. They haven't passed up any other opportunities that might have taken the place of what I'm doing, right? So promissory estoppel would not apply. There has to be a clear and definite promise. The promise has to be relied on to that person's detriment. And then there has to be the only way to avoid injustice would be to enforce that promise. Another thing that the court might do in my first example is they might say, okay, Mr. Tebow, you don't have a contract, but you did make a promise and you led them on. They relied on it. They're out the cost of the land and whatever they've paid the architects. So we're not gonna make you pay $2 million that you promised, but I am gonna make you pay for what they've done in reliance on your promise, which is you're gonna have to at least give them enough money to cover the land or the expense that they've gone to. The idea being we're just trying to avoid injustice. That's the idea of promissory estoppel. All right. So there is no contract, but the court might still enforce the promise. Another example where we might have the court enforce a promise even when consideration is lacking is something called a quasi-contract. All right, and it's more based on less express promise than implied promises or actions. So the example in your outline is you are sitting on your front porch and you notice a paving company come and they are supposed to pave your neighbor's driveway, but they made a mistake and they're preparing to pave your driveway instead. You sit there and watch them do it. They park in front of your yard, they're walking up and down your driveway, they're doing measurements, they're backing up the cement truck or the asphalt truck or whatever it is. They're doing all this site prep and you're just watching them knowing that they've made a mistake there at the wrong place. In that case, if they sued you, your defense at court would be what? I did not enter into a contract with these people. I didn't make any promise. That is their mistake, not my mistake. There's no consideration given. This is no contract. The judge might say, yeah, you're right. I'm not going to enforce it under the idea that you breached a contract, but I am going to at least make you pay them for the reasonable value of the services that you were enriched by knowingly. Okay, the key to that example is that I sat there and watched them do something that I know I wasn't entitled to. If I go to Hawaii on vacation and come home and find out that they accidentally paved my driveway, a lot less likely that they're going to be able to take me to court to make me pay for something that I, number one, didn't ask for, and number two, had no opportunity to stop them from doing. Quasi-contract prevents unjust enrichment, somebody from getting a windfall. The key is that the hands of the person who got the benefit are what we would say they're kind of dirty hands, unclean hands. You knew you were getting a benefit that wasn't yours and you didn't do anything to stop it. So we may not make you pay top dollar for what you got, but we at least maybe might make you pay cost or something. You're not going to get away with getting the benefit for nothing. These things don't happen very often. Promissory estoppel and quasi-contract are not common, but they do happen. All right, I'm going to move to part 2 of the outline. So everybody pull up lecture outline, contract law part 2. And you will see that takes us to the third element of a contract, which is capacity. So the general expectation is that people who enter into contracts have the legal capacity to do so. That's our general starting point. The law presumes that anybody who enters into an agreement has the legal capacity to do it. But there's some situations where a person might not have capacity or where it may be questionable. Okay? And in those situations, the party who lacked capacity will sometimes have the right to avoid any contractual liability. They can get out of the contract. That's a defense to breach of contract. I didn't have capacity. Either I didn't know what I was agreeing to, I didn't do it voluntarily, you hid something from me. We're going to go through all the different ways that a person could lack capacity. The first is minors. So here's the rule for minors. A minor can enter into any contract that an adult can, but the minor has the right to get out of it, to quit it, to terminate the contract, to avoid liability. The adult that's on the other side does not have that right. So let's assume that my 16-year-old daughter goes to the car dealership to buy a car. Okay, she buys a car. They enter into a written contract. I agree to sell you this car. You agree to pay me X amount of money for it. Everybody signs it. We've got an agreement. We've got consideration. It's legal to sell somebody a car. So we're looking at the third element of capacity. Minors can enter into the contract, but they have the right to avoid them. So my daughter could go up the next week and drop the car off and say, I've changed my mind. She could legally do that. If the car dealership sues her for breach of contract, her defense is, I didn't have capacity to contract. I wasn't 18. Age of majority is 18. The car dealership does not have that same right. So the car dealership couldn't come back the next month or the next year and say, give us the car back. We're going to give you your money back. We want to get out of the contract. They can't do that. The adult runs the risk. If an adult enters into a contract with a minor, the law presumes that they know that they cannot enforce the contract against the minor, but the minor can enforce the contract against them. And that doesn't mean that like my daughter could go buy cars at 5 dealerships this weekend in Columbus and then laugh at them and just not pay them and keep the car. I mean, if they sued her, the court would find that there was no contract because she doesn't have capacity, but she'd have to give the car back. She didn't get to keep the car. All right, what happens when a minor enters into a contract before they turn 18, but then they turn 18? So my daughter pays on this car for 2 years. She turns 18, and when she turns 18, she keeps on paying for the car, and she pays it off. It's hers, no issues. If she turns 18 and on her 18th birthday, she takes that car up to the dealership, puts it in park, throws them the keys and says, ha ha, suckers, I'm out of this contract. I don't want it anymore. She could do that. The law says that a minor, upon reaching the age of majority, has the right to disaffirm the contract, to get out of it, to cancel it, but they have to do it within a reasonable amount of time. If they don't do it within a reasonable amount of time, or if they make some outward objective expression of an intent to continue to be bound by the contract, then they're stuck with it. It's as if they made a contract upon becoming an adult. So where that might get murky is, let's say that my daughter turns 18, she makes 1 month of payment, and then she goes and turns the car in. Has she disaffirmed the contract within a reasonable amount of time? What do y'all think? I mean, probably. I could argue both ways, but I can make a better argument for her. What if she waits 6 months? See, that feels a little bit different, right? All right, so where do we draw the line? We said 1 month felt reasonable, 6 months didn't. So then you get into 2 months, 3 months, 4 months. Where does that lie?
I mean, if it's a car, like depending on how much mileage you put on it. But
Yeah. It's going to depend on the facts and circumstances, because who's ultimately going to make the decision about what was within a reasonable amount of time? In the court system, who? The judge or the jury. The judge if you just have a bench trial with no jury. The jury if you have a jury trial. So they're going to take all that into consideration. The law isn't going to say, there's not going to be a written statute that you can look up that says if a minor buys a car before 18 that they have to revoke the contract within 2 months of turning 18. There's no bright line test in the law. The law just says within a reasonable amount of time. I can think of, maybe somebody turns 18 and they are deployed overseas with no communication. They come back 10 months later from deployment, surface again as soon as they get back into the real world where they can do communications, and they disaffirm the contract. That might be a reasonable amount of time under the circumstances. Just going to depend. All right. Intoxicated persons. So the issue with intoxication as a defense to capacity, this intersects with something we talked about Tuesday, being that the courts apply the objective theory of contracts when they're looking at all these facts and circumstances. So I might be hammered out of my mind, but objectively, if I'm going to try to get out of that contract by saying I didn't have capacity, I've got to be able to show the court evidence and facts that would support that. Not, I was so drunk, I had no idea what I was doing. If I could just go to court and say that, then we could use that as a defense to pretty much anything, right? Well, Mr. Tebow, you were at the car dealership at 11 in the morning. Yeah, but I stayed out all night. I was so high on pills that, I don't even remember what all I took. Okay? That's not going to get me out of liability for the contract unless I've got evidence that show that I've got witnesses that can say he passed out in the car dealership and the salesman put the pen in his hand and, kept directing him where he said, I heard him say many times, I can't even read. I'm so drunk I can't even read. It's going to have to be objective facts that support that there was no capacity. Good. If I'm at the car dealership at 11 a.m., it's going to be a lot harder for me to present objective evidence that I was intoxicated than if I sold the car, we made the deal at a bar at 2 a.m. on a weekend. Right, that might be a little bit easier. I've got a head start on my evidence there, right? First of all, Your Honor, we were in a bar at 2 a.m. That's a lot better objective fact than it was 11 a.m. on a Monday at the car dealership. All right, one of the cases you've been assigned for Tuesday is a case where two gentlemen made a deal to sell some land at a bar on Christmas Eve after they had both been drinking. And so the question before the court, as you read through the case, they talk a lot about objective evidence, what people said, what people heard, where the contract was written. Was it on a cocktail napkin? Was it on the back of a restaurant ticket as opposed to something that we printed out off a website that helps us draft contracts, things like that. So pay attention when you read that case on all the evidence that's good for both sides. It's a case that is not a clear-cut case. So after we talk about it Tuesday, I'm going to ask you, like I did with the McDonald's, which is, what do you think? Who do you come down on the side of more? So pay close attention to the objective facts as you go through that. Mentally incompetent persons. This is hard to prove. Mental incompetence is, well, let me take that back. it can be hard to prove. All right. Most of the time, as with intoxication, it's just not as clear cut as to where do you cross the line between somebody being under the influence but still knowing what they're doing. Where do you cross that line into being under the influence to the point that you don't know what you're doing? Same for mental incapacity. How much incapacity is enough for us to say the person didn't really appreciate the bargain that they were making, the obligations that they were undertaking, that sort of thing. In Georgia, and in most states, people are presumed to have the mental competence to enter into a contract unless they have been taken before a court and the court declares them incompetent. That doesn't happen very often. In Georgia, it looks like this. If you had a grandparent or if you had a developmentally disabled child who's over the age of 18 and you believe that their impairment was such that they really shouldn't be, they don't have the ability to be entered into contracts to understand what they're doing. We know what that looks like for extreme cases. My grandmother has dementia or Alzheimer's to the point where she doesn't know who I am. Okay, that's an obvious one. What's less obvious is when my grandmother is in the beginning stages of her Alzheimer's and she has good days and bad days. Harder to prove that this was one of the days when she didn't understand what she was doing. I mean, I could subpoena the doctors to come in. Hey, does my grandmother, she sees you, you're a neurologist. She sees you for what? For Alzheimer's. When did you diagnose her with Alzheimer's? I diagnosed her 3 years ago. Do you prescribe her medicine for it? Yes. How often? I mean, I can prove that she has it, but I've still got to prove that she has it to the point where she didn't understand what she was doing that day. Even Alzheimer's patients have some what we call lucid intervals. During the day, they're better than after the sun goes down. It's just more difficult to prove. So the way it works in Georgia is if you think that someone doesn't have the capacity, then you go to probate court. That's the court of jurisdiction for guardianships. And you file a petition saying, I think this person doesn't have the capacity to make significant responsible decisions for themselves. They need a guardian to be their legal decision maker, and they need to have their right to make decisions taken away. When that happens, then the court appoints a doctor to evaluate the person, and the person has to go see that doctor. The doctor does an exam. The doctor does a report back to the court. Yes, I think this person has capacity. No, I don't think this person has capacity. Then you'd have to actually, if it's contested, you'd have to actually go into court and convince the court that this person, given all the facts and circumstances and evidence, doesn't have capacity. If the court finds that, then they will take away that person's right to enter into a contract. Very rare. Our country is built upon foundational principles that we have the freedom to act however we want. We have the freedom to make bad decisions if we want. We have the right to think for ourselves. So it takes a lot for a court to remove somebody's ability to enter into contracts, but it does happen. If I do that, if I go to court and have a guardian appointed for Nana, then any contracts that Nana enters into, she can get out of, because we could go to court and say, she was declared incompetent by the probate court of Muskogee County in 2019. The court took away her right to enter into a contract. Case closed. Okay? The harder cases are the ones where somebody does have limited capacity, but a court hasn't necessarily declared that yet. Those are much harder cases. I remember it's been a while. Well, I think I was just getting out of law school, so 30 years ago, and some salesman, door-to-door salesman, sold my grandmother some walk-in, one of those walk-in tubs or something, that you see on the infomercials and stuff. And I was like, yeah, we're not, no. So I just called up the people and said, she's not going to, we're just canceling this contract. If you want to sue us, sue us. And of course they didn't, because we talked about that Tuesday too. You make some decisions based on, did they really want to go and sue my grandmother in a court in her small South Georgia county and try to convince a jury that they didn't take advantage of a little old lady who probably knows half the people? And that's just not smart business practice for that company. Nowadays, people might go on TikTok Live and talk about how this company takes advantage of old women. It's just not worth it for them. So nothing ever became of that. They could have enforced the contract if they wanted to, but they decided that they didn't want to take that chance. That takes us to legality. So the element of legality just means that the subject matter, the purpose of the contract has to be legal. The example I used Tuesday was if I hired one of you to kill my enemy, so a contract to commit a crime. If Big Worm hires me to deal his weed, right, and I sell his weed and give him the money and he doesn't pay me for the work I've done, I can't sue him in court because dealing drugs is illegal. So the subject matter of our contract was not legal. Contracts that are contrary to statute, that means if we've made a law that something's illegal, not just like murder for hire or dealing drugs, but like we have laws that say you can't charge interest rates that are above a certain amount. If I enter into a contract with Justice to loan him some money at an interest rate of 50%, and he sues me to get out of it, or no, I sue him to enforce it, his defense is we don't have a contract because it didn't have a legal purpose. It's illegal to charge 50% interest. We had an example, I think it was, Levi, was it you and Ramon that have a bet on the Falcons? Yeah, that was a question that somebody asked. What if we have a bet on the Falcons making the playoffs? How would we enforce that? And the answer would be you couldn't, because gambling is not, I was about to say gambling is not legal. Some gambling is legal now, but not in all forms, and that's not one of the ways. Now, if you placed a bet, Levi, with a sports book that's licensed in New York, and you won your bet and they didn't pay you, you can absolutely sue them because they're involved in legal gambling. Okay, but if Ramon just is running a bookie operation on the side and he stiffs you, you're out of luck on that. Licensing statutes, like it's illegal to practice law without a license. It's illegal to do hair without a license. It's illegal to drive a vehicle without a license, right? So in order to do some things, you got to be licensed. So that might be an issue. A situation where it lacked legality. You've all heard of non-compete agreements. Those are also illegal. So a non-compete agreement, if you don't know, is when you sign an employment contract with your employer and it says something like, if you're fired or if you leave, if you quit your job, you agree not to work for a competitor for X number of days, weeks, months, years within X mile radius or within X industry. Okay, those are legal, but the courts will look at those pretty strictly. So so let me say that both ways. I'm saying that two ways, both sides of my mouth. They can be legal. They can also be illegal. They are illegal if their scope is too broad. I'm going to give you some examples in a minute. If their scope is too broad in terms of what it's prohibiting a person from doing, how long it's prohibiting them, the geographic area. If all those are excessive and not really necessary to protect the employer's business or interest, then the courts won't enforce them. So let's say that I get hired as a salesman, a software salesman in the Southeast US. And my employer says, as part of this job, you're going to have access to our customer list. You're going to have access to our proprietary, our invention or whatever it is that you're selling. You're going to know about our research and development. You're going to have a lot of information that would be harmful to us if you left. Nothing wrong with that idea of wanting to protect that. So in order to protect our interest, I mean, I'm not going to hire salesmen that could, my competitors could send over somebody to learn everything from me and then, quit one day and bring it to me. I need to protect my interest in what I own and what I've built. So I might say, James, I would love for you to be a salesman, but in order to protect my interest, you have to promise that if you quit or if I fire you, that you won't work for, you will not work for somebody selling software. Let's say it's accounting software. You will not work for anybody selling accounting software for a year in the Southeast United States. So that the scope is accounting software. That is what you're selling for me. The geographic scope is Southeast United States, which is your area. So you're going to know the customers and the customer list and have built up relationships. And the time period is a year. So after a year, you can do whatever you want. That feels more reasonable than if the agreement was, James, if I hire you to sell my accounting software and your area is the Southeast United States, but I'm going to ask you to promise or ask you to be bound by contract that if you leave, you will not work as a salesman for 10 years worldwide. That's excessive to protect my interests, right? What if he wants to go sell cars in Korea? That doesn't affect my proprietary interest in my accounting software, right? That would be excessive. So a covenant not to compete or a non-compete agreement can be legal if it's limited to a proper scope in terms of subject matter, duration, and geographic area. That makes sense to y'all? The more expensive they are, the less likely they are to be found to be legal. Yes. All right, so how would that work for multinational enterprise? Let's say that the job that I was hiring James to do was that he was going to be in charge of sales and distribution. He is my global vice president of sales and distribution for Microsoft. Okay. If I'm Microsoft and I want to protect myself, then I might say, you can't work for another tech company for 2 years worldwide. I could make the argument that's not excessive to protect my interests. Now, he could make the argument that any tech company is excessive, right? It's going to depend on the facts and situations. So it would need to be reasonable in scope of subject matter, duration, and geography. Does that make sense? I can make the argument that worldwide is not too much of a reach, but it's the larger the scope, the less likely it is to be legal. Good question. All right, so what else is illegal? Remember I told you that the courts are not going to get you out of a bad deal. But there are times when a deal is so unfair that the court might say it's unconscionable. If we enforce this contract, it would shock the conscience. It's just so egregious that there's no way we're going to enforce it. Okay? Maybe if a contract said something like, Jackson, I'm going to build a house for you. You're hiring me to build a house, and you're going to pay me $1 million up front. And at any time between when you pay me and I finish, I could just decide to walk away. And if I decide not to build your house, you don't get your money back, and you are going to give up your right to sue me. In other words, I'm going to write into the contract where basically there's nothing you can do. That feels egregious and unconscionable. Like, okay, on the one hand, does Jackson have the personal responsibility to not sign a contract like that? He does. If Jackson is CEO of a Wall Street company and he's got 5 degrees and he's one of the smartest financial people in the world, he's got a law degree and he practiced contract law for 20 years, and he tried to sue me to get out of that contract, it's a lot less likely that that's unconscionable, that the law should rescue him from a bad deal, because he should know better. Right? If Jackson is English is his second language, he was born in another country, came here, learned English while he was in college, he's from a third world country that doesn't have any development, he and I get to talking at the Chili's bar on a Friday night, and I tell him I'll build him a house, and we whip out an agreement right there on a cocktail napkin, and it's so unfair that I'm scamming him basically, then he might be able to get out of that. It was there's something so unfair about it that the court is not going to enforce it. You could have procedural unconscionability, like there's just something wrong with the way it was negotiated. I put him under pressure. I approached him. I told him he had 30 seconds to decide yes or no. I mean, procedurally, I could make it unfair, but I could also make it substantively unfair, where the contract is just written in ways that it's completely unfair and unenforceable for him. That's an unconscionable agreement. Doesn't happen very often. So you all have probably signed a contract in your life that includes an exculpatory clause. That's the clause in a contract that says if something goes wrong, you will not sue the other person for damages for whatever it is that went wrong. Like you guys, if you some of these damage waivers, when you go on a ride or you go play paintball or whatever, a lot of the agreements that you're signing have language in there that says if I'm hurt, I agree that I will not sue the provider. You see them all the time. They're in your rental agreements. They're in a lot of the user agreements that you see. Okay, those can be legal in some instances, and in some instances they're not. It just depends on how oppressive they are. Like I could not. Let's say I run that paintball warehouse, and before anybody participates, we agree in contract. Okay, I'm going to let you play, but in exchange for me letting you play, you're going to pay me, but you're also going to sign this agreement that says that you're not going to sue me if you get hurt. Okay, that could be legal if I get you to agree not to sue me for the regular dangers that are present in paintball, for the things that I've warned you about, for the obvious risks. If I get bruised because the paintball hits my skin, all right? That might be legal. But if I make you sign something that says, I will not sue you no matter what happens to me here, whether it was my fault or your fault, even if you did something grossly negligent, I am giving up my right to sue you no matter what happens. That might not be legal. Okay? So just because a contract says that in there does not necessarily mean that it could be enforced later on. But if we had a dispute over that, that would involve litigation and cost and all that kind of stuff, right? I get hurt at the paintball warehouse. I feel like the paintball warehouse should be responsible for it because there was a big hole in the floor with no warnings and no repair, and I fell through it and broke both of my legs. And they say, well, too bad you signed this waiver saying that you wouldn't sue us if you got hurt. If I want to sue them anyway and try to invalidate that part of the contract, we got to go to court. Okay, so when we talked Tuesday about the practical considerations with contract law, that's one of them. Is it worth it to me to sue this person? Is it worth it to me to fight this person, or should I just go ahead and pay him out? Businesses make those decisions all the time. So a lot of contract enforcement really involves a cost-benefit analysis by the parties to determine, is it worth it for us to litigate this? All right, final topic. Well, I've got a little bit more to say. Yeah, let's use our 5 minutes. Let me keep going. All right. Section 3 in your outline, voluntary consent. So that would be a defense in court to enforcement of a contract was it wasn't the consent wasn't voluntary. I was forced to do it. That might look like duress. The person forced me into it by threatening me or putting pressure on me that was unfair, so that I really didn't knowingly, willingly, of my own intention enter this contract. I was forced to do it. Threats are usually the way that duress shows up. Undue influence is another way that it might show up. Let's say that Nana has Alzheimer's. No, let's say Nana doesn't have Alzheimer's, but Nana has round-the-clock in-home care. And her in-home care nurse, she's known for 3 years. She trusts her. Nana doesn't get out of bed, but the in-home care nurse brings Nana stuff to sign that gives the in-home care nurse raises or interest-free loans or something like that. Nana is signing it because she trusts the caregiver. She doesn't really have any way to independently find out if this is a good deal or what. She's just taking this person's word for it, right? You can think in your mind these situations. Then the consent to the contract might not be voluntary. There was undue influence, a power imbalance, an information imbalance. Those might be defenses to contract enforcement. Fraud is a defense, okay? I didn't knowingly, willingly, intentionally agree to something if you were misrepresenting a material fact to me, okay? I go to buy a English Bulldog from Tim, and he tells me that it is a purebred AKC registered English Bulldog with papers. I agree to buy it. We sign a contract. I find out 2 weeks later that this dog is not, in fact, AKC registered, does not have papers, and Tim knew that. That's fraud. I can get out of a contract if fraud has been perpetrated on me, because it would negate my voluntary consent to the contract. Yes.
So does the fraud have to be in writing, like in that example? Does it have to say, I will pay this amount for X, Y, Z, like the AKC registered papers, dog?
Does the fraud have to be in writing? Not necessarily, Damien, but the law, if you do put an agreement in writing, the law favors what you put in writing. And so if you go to court and say, well, Tim told me it was AKC registered, but the contract doesn't say anything about that, I'm going to have a harder time making out my fraud case. Not because he didn't lie to me, but because the court is going to say, we can't deal with what was said, or we can deal with it, but we can't deal with it as easy as we can deal with what you put in writing. And so if y'all were talking about that, but then you actually had a written agreement and you didn't put it in the written agreement, we're not getting into what might have been said while you were negotiating or you were preparing your deal or whatever. So that is a good practical lesson, is that if you're basing your contract on a representation that's been made by the other party, it needs to be part of the writing. That's a great question. Otherwise, what we could always do is just go to court and say, well, Tim lied to me. He said all these other things too. He said this dog had a famous dad, or whatever. And the court is not getting into back and forth and he said, she said, and what y'all might have meant, or what you might have heard, what you might have said. They're going to be more interested in what you actually thought was important enough to put in writing. All right, let's talk about mistake. Well, I'm going to stop there. On Tuesday, I'm going to talk about what happens if the parties make a mistake. And then I'm going to talk about which contracts have to be in writing. And then we're going to talk about the Wright versus Newman case, which involves promissory estoppel. And we're going to talk about the Lucy versus Zemer case, which involves capacity to enter into a contract. No quiz due Monday. All I need you to do for Tuesday is to read those cases. See y'all then. If you came in late, let me know. Justice, hang on, let me make sure I got you.